start our opening sessions, I would like to read today's agenda. First, keynote speech and seminar introductions. Second, discussion session. And the third, closing for international seminar. Excellencies, participants, ladies and gentlemen. Now, we would like to request the honor from the Excellencies, Mr. Febrian A. Rudyard, as Deputy Minister for Multilateral Cooperation, to deliver the keynote speech in this international seminar. Please welcome Mr. Febrian A. Rudyard. The floor is yours, sir.
Thank you very much. Thank you very much, Ibu Moderator, Ibu Sadra Moniaga, member of the National Human Rights Commission, thank you for arranging this event, and also my colleague, Pak Dirjen Mualimin Abdi from Ministry of Law and Human Rights, distinguished participants, ladies and gentlemen. On behalf of the Minister for Foreign Affairs of the Republic of Indonesia, who regretfully is unable to be with us today, I have the honor to give remarks in front of members of National Human Rights Institution, state actors, experts, and media in this international seminar on national and international initiatives on torture prevention. We welcome the works of the Southeast Asia Nation Human Rights Institution Forum, in which Indonesia National Human Rights Commission is a member, as an organization that has played a significant role in the promotion and protection of human rights in the region since 2003. It is very unfortunate that we are unable to meet face-to-face due to the ongoing pandemic. Hopefully, the discoveries of the vaccine can be a game changer to the current situation. Distinguished participants, the promotion and protection of human rights is a priority in Indonesia's diplomacy. It is proven by our membership in the Human Rights Council 2020-2022, where Indonesia got elected by 174 countries, the highest in the Asia-Pacific group. The international community are trusting Indonesia to take the bigger part in the protection and promotion of human rights. Ladies and gentlemen, every nation in the world condemns the act of torture and other cruel, inhuman, or degrading treatment or punishment. In international law, the prohibition of torture and other inhuman treatment is a jus cogens, a set of fundamental norms accepted by international community, which no derogation is permitted. As a state party to United Nations Convention Against Torture or UNCAT, Indonesia continues to develop its national and local legislation, institution, and mechanism to prevent and combat acts of torture and inhuman treatment. To further our commitment, Indonesia is also a founding member of the Convention Against Torture Initiative, or CTI, back in 2014, alongside with the government of Chile, Denmark, Ghana, and Morocco. The CTI is an innovative joint collaboration between four states and focuses its work on making the UNCAT universally ratified and better implemented. In doing so, CTI core states aspire to support non-state parties of UNCAT to overcome the obstacles in ratifying and implementing UNCAT by facilitating technical advice, support, and cooperation among states. In November 2019, Indonesia hosted the second CTI regional seminar to share good practices in constructing legislative and institutional frameworks and to exchange methods to improve the capacity of our law enforcement agency. We are proud that we managed to invite 18 Asia-Pacific countries to participate in the seminar. Not only the government official, but also members of national human rights institutions and experts. The event demonstrated the importance of prevention measures to promote and protect human rights by improving the capacity of states, creating enabling environment for peace and prosperity, as well as some other things. There are 6 out of 10 ASEAN member countries are party to the UNCAT. We are heartily encouraging countries who has not ratifying UNCAT to be a party. It took Indonesia 13 years to go from signing to ratifying the UNCAT. Therefore, we understand the challenges that stand in between. The universalization of the UNCAT is not the end game. The full implementation of the UNCAT is the next challenge that all state parties must face. Ladies and gentlemen, at the national level, the explicit prohibition of torture and other inhuman treatment are already provided in the proposed draft of the new criminal code, or we call it RKUHP. It is indeed a heartening development since the current criminal code does not explicitly define torture. It is also important to underline that the definition of torture is already clearly provided in the law number 39, year 1999 on human rights. Distinguished participants, we are also welcoming the initiative from several Indonesian human rights institutions, namely the National Human Rights Commission, the National Commission on Violence Against Women, the Indonesian Child Protection Commission, and the Witness and Victim Protection Agency to form kerjasama untuk pencegahan penyiksaan, or we usually call it as CUP, or in English we call it the Cooperation for the Prevention of Torture. The works of CUP include, among others, signing the MOU with the Ministry of Law and Human Rights and signing the cooperation agreement with Directorate General of Correction and Directorate General of Immigration of the Ministry of the Law and Human Rights. To facilitate sharing of experience or good practices through a constructive dialogue and by monitoring correction and other detention places to prevent torture and other inhuman treatment is commendable. Distinguished participants, the challenges in addressing the issue of torture must be faced not only by states, but also by national human rights institutions and civil societies. I hope you will have a productive discussion in today's seminar. I thank you.
All right, thank you, Mr. Fabian Arudio. For the next keynote speech, please welcome Mr. Mualimin Abdi. As Director General of Human Rights, to deliver the keynote speech. To Mr. Mualimin Abdi, the time is yours. To continue to our next speech, I would like to invite Mr. Ahmad Taufan Damani, a chairperson of National Commission on Human Rights in Indonesia, kindly deliver the opening remarks and to officiate this international seminar. The time is yours, sir.
Thank you very much. His Excellency Mr. Febrian Rudiat, Deputy Minister of for Multilateral Cooperation of Indonesian Foreign Minister, and Dr. Mualimin Abdi, the Director General of Human Rights, the Ministry of Law and Human Rights, the resource persons, my colleague Sandrayati Moniaga, Commissioner of Komnas HAM, and also Ms. Sajira Zawawi, Senior Research and Advisor of APT based in Geneva, Mr. Gerald Joseph, Commissioner of Suhakam Malaysia as moderator, and of course, Commissioner from Witness and Victims Protections Institutions, from National Commission on Violence Against Women, Ombudsman of Republic of Indonesia, and Commission for the Protection of the Rights of Children, and all participants. Indonesia is one of many constitutions that explicitly respect the right to be freed from torture. Article 28J, paragraph 2 stated that every person has the right to be free from the torture or treatment that degrading human dignity. And Article 28I, paragraph 1, regarded that this right is non-derogable rights. It stated the right to life, to remain free from torture, to freedom of thought and conscience, to adhere to a religion, the right not to be enslaved, to be treated as an individual before the law, and the right not to be prosecuted on the basis of retroactive uh, legislation and fundamental human rights that shall not be curtailed under any circumstances. Indonesia has also ratified the United Nations Conventions against torture and other cruel, inhuman, or degrading treatment or punishment, UNCAT, or the Conventions Against Torture and other cruel, inhuman, or degrading treatment or punishment through the law number 5 of 1998 concerning ratification of the Convention Against Torture and other cruel, inhuman, and degrading treatment or punishment, and has expressed its commitment to combat torture. There are some laws or regulation on prevention on torture in Indonesia. It is also involved in Indonesian constitutions, year 1945, Article 28I, number 1 and number 2 that I already mentioned. Law number 5 of year 1998, law number 12, 2005 concerning ratification of the Covenant on Civil and Political Rights, human rights law number 39, year 1999, and also National Law on Human Rights Code, 2000, year 2000. There is also Police Regulation number 8 of 2009 concerning the implementation of human rights principle and standard in the implementation of police duties. Indonesian Army Commanders Regulation number 73 9 2010 concerning opposition to torture and other cruel treatment in law enforcement within the Indonesian Army. So police and Indonesian armies also adopted some principle of anti-torture. Over 2 decades since ratification of UNCAT, Indonesia has not ratified the optional protocol to the Convention Against Torture, or OPCAT. OPCAT, with its 2 pillars, has important roles in optimizing the prevention of torture. First pillar, it introduced an additional and practical element to combat and prevent torture and ill treatment, other cruel, inhuman, or degrading treatment or punishment. To prevent the act being carried out, a state party has general obligation to respect, protect, and promote human rights. It should take effective measures to prevent it. The second pillar is the formation of appointment of National Preventive Mechanism, or NPM. Its main mandate is to conduct regular monitoring, visits to all types of places where persons are deprived of liberty. Through these visits, NPMs, National Preventive Mechanism, are in a good position to identify early warning signs and therefore prevent abuse. It complements the work of the UN Subcommittee on Prevention of Torture, or SPT, and can have direct contact with the subcommittee. Although Indonesia has yet to ratify OPCAT, 5 state institutions, National Commission on Human Rights, of Komnas HAM, National Commission Against Violence Against Women, Komnas Perempuan, Commission for the Protection of Indonesian Children, Ombudsman of Republic of Indonesia, and Witness and Victim Protection Institutions for the last 3 years has come together to cooperate in the prevention of torture, called KUPP, Kerjasama untuk Pencegahan Penyiksaan. Despite the cooperation, NPM Indonesia has not established. However, it provides a platform for stakeholders to develop their understanding, trust, mechanism, principles to prevent the recurrence of torture and ill treatment. The institution have developed cooperation, coordination and working patterns as well as best practices in monitoring correction institutions. For this, it is important that torture prevention body need to be independent, free from government influence and provided with sufficient resources to carry out their work effectively. They must also have the power to access all places of detention without restriction, to access all information and to be able to talk with detained person in private. The 5 institutions have collaborated with Directorate General of Correction and Directorate General of Immigration, and looking forward to have the same MOU with the Indonesian National Police and Ministry of Social Affairs. KUPP is also delighted to have the support from the Ministry of Foreign Affairs and Social Affairs and for the ratification of OPCAT. Our recommendation for the future: Indonesia has a special place in the UN Commission on Human Rights and has significant role both at global and regional in the promotion of human rights. Indonesia should show its commitment to combat torture and ill treatment, the ratification of OPCAT. There are rules and regulations, including a kind of SOP within the security institution and law enforcement, including correction institution, to prevent torture. We believe that constructive dialogue and better transparency will strengthen the work of the institutions. KUPP, or corporations among 5 national institutions, is available to work together with the institution in preventing torture. Thank you very much to all participants. Good afternoon.
Good afternoon, and thank you very much, Mr. Ahmad Taufan Damanik, for the keynote speech. And for the next keynote speech, please welcome Mr. Mualimin Abdi, as Director General of Human Rights, to deliver the keynote speech. To Mr. Mualimin Abdi, the time is yours, sir.
Thank you. I'm Indonesian language. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Om Swastiastu. Salam Namo Buddhaya. Salam kebajikan untuk kita semua. Yang saya hormati Pak Ahmad Taufan Damanik, Ketua Komisi Nasional Hak Asasi Manusia. Kemudian ada Pak Febrian A. Rudiat, Direktur Jenderal Kerjasama Multilateral, Kementerian Luar Negeri. Kemudian ada Ibu Sandriati Muniaga, Komisioner pada Komisi Nasional Hak Asasi Manusia. Kemudian ada Ibu Zazira Zawawi, Peneliti dan Penasehat Senior, Association on the Prevention of Torture. Kemudian Bapak Ibu semua narasumber, hadirin hadirat yang saya hormati. Izinkan pertama Pak Menteri Hukum dan Hak Asasi Manusia tidak bisa mengikuti kegiatan ini karena ada kegiatan yang tidak bisa ditinggalkan, sehingga beliau menyampaikan kepada saya untuk membacakan keynote yang semestinya disampaikan oleh Pak Menteri Hukum dan Hak Asasi Manusia. Pertama-tama marilah kita panjatkan puji syukur kehadirat Tuhan Yang Maha Esa, karena hanya berkat limpahan rahmat dan hidayahnya kita dapat hadir pada kegiatan bertajuk seminar mengenai inisiatif nasional dan internasional dalam pencegahan penyiksaan yang diselenggarakan oleh Komisi Nasional Hak Asasi Manusia. Sungguh sesuatu yang berbahagia kita masih dapat melakukan diskusi dan seminar mengenai hal yang sangat penting ini, yaitu terkait dengan pencegahan penyiksaan di tengah-tengah kondisi yang teramat sulit karena adanya pandemi COVID-19. Kami berharap Bapak Ibu sekalian tetap sehat dan tetap menjaga protokol kesehatan dimanapun Bapak Ibu berada. Bapak Ibu yang saya hormati, pencegahan penyiksaan merupakan amanat konstitusi yang menjadi komitmen negara, yaitu negara Republik Indonesia, sebagaimana tercantum di dalam pasal 28G ayat 2 Undang-Undang Dasar Negara Republik Indonesia tahun 1945. Ketentuan tersebut telah mengatur bahwa setiap orang dalam keadaan apapun harus bebas dari bentuk penyiksaan. Hal ini dipertegas dengan sikap pemerintah untuk turut meratifikasi Konvensi menentang penyiksaan melalui Undang-Undang Nomor 5 Tahun 1998, yang mana dalam salah satu ketentuannya menyebutkan bahwa negara wajib melakukan langkah-langkah pencegahan, baik melalui mekanisme legislasi, melalui mekanisme administrasi, maupun mekanisme aturan-aturan atau instrumen hukum yang lain. Sebagai tindak lanjut dari pencegahan penyiksaan di Indonesia, pemerintah melalui Kementerian Hukum dan Hak Asasi Manusia telah mendukung ditandatanganinya Memorandum of Understanding antara 5 lembaga yang terkait di dalam upaya pengawasan dan pencegahan penyiksaan dan perlakuan atau penghukuman lain yang kejam, tidak manusiawi atau merendahkan martabat setiap orang yang berada di tempat-tempat penahanan. Kelima lembaga tersebut adalah Komnas HAM, Ombudsman Republik Indonesia, Lembaga Perlindungan Saksi dan Korban, Komisi Perlindungan Anak Indonesia, dan Komnas Perempuan. Di mana MOU ini atau Memorandum of Understanding ini telah ditandatangani sejak tahun 2016. Kemudian MOU tersebut ditindaklanjuti dengan perjanjian kerjasama antara 5 lembaga tersebut dengan Direktorat Jenderal Pemasyarakatan dan Direktorat Jenderal Imigrasi, Kementerian Hukum dan Hak Asasi Manusia dengan melakukan penelitian pada 10 lembaga pemasyarakatan atau rumah tahanan di Direktorat Jenderal Pemasyarakatan Kementerian Hukum dan Hak Asasi Manusia yang terkait antara lain masalah overcrowded, layanan kesehatan, fasilitas makanan, minuman dan air bersih, rasio petugas dengan tahanan, hak informasi bagi tahanan, yaitu yang antara lain terkait dengan cuti bersyarat, cuti menjelang bebas, pembebasan bersyarat, remisi, dan hak-hak warga binaan lainnya. Adanya dugaan tindak penyiksaan pada proses penyidikan yang biasanya ada di kepolisian adanya dugaan tindak pidana penyiksaan di dalam rutan atau lapas, serta tidak adanya pemisahan warga binaan dan tahanan di lapas dan rumah tahanan. Inilah antara lain yang ada di dalam Memorandum of Understanding yang ditandatangani oleh 5 lembaga yang tadi saya sebutkan di atas. Peserta seminar yang berbahagia, pemerintah dalam hal ini Kementerian Hukum dan Hak Asasi Manusia melalui Direktorat Jenderal Hak Asasi Manusia terus berupaya mengarusutamakan konvensi anti penyiksaan dengan melakukan langkah-langkah pendekatan berbasis peningkatan pemahaman kepada para aparat penegak hukum yang terkait seperti petugas lapas atau sipir, petugas detensi imigrasi, kemudian terhadap kepolisian, terhadap TNI, praktisi hukum, hakim, jaksa, maupun Satpol PP. Yaitu sejak tahun 2010, Direktorat Jenderal HAM telah menyusun modul sosialisasi CAT itu sendiri bagi aparat penegak hukum. Modul ini kemudian disosialisasikan ke berbagai daerah di Indonesia sejak tahun 2011 kepada lebih dari 400 aparat penegak hukum. Direktorat Jenderal Hak Asasi Manusia juga telah menyusun pembaharuan pada modul sosialisasi menentang penyiksaan dengan menambahkan bab tersendiri mengenai wawancara investigatif yang mengedepankan teknik wawancara dengan pendekatan berbasis hak asasi manusia. Selain itu, kami juga memberikan beberapa kuliah umum mengenai pentingnya pencegahan penyiksaan kepada para taruna dan taruni di Politeknik Ilmu Pemasyarakatan atau Poltekip dan Politeknik Keimigrasian atau Poltekip di Badan Pengembangan Sumber Daya Manusia, Kementerian Hukum dan Hak Asasi Manusia. Selain itu, dalam skala nasional, Kementerian Hukum dan Hak Asasi Manusia telah mengeluarkan Peraturan Menteri Hukum dan Hak Asasi Manusia Nomor 10 Tahun 2020 dan Keputusan Menteri Hukum dan Hak Asasi Manusia Nomor MHH-19 PK 0104 Tahun 2020 tentang pengeluaran dan pembebasan narapidana dan anak melalui asimilasi dan integrasi dalam rangka pencegahan dan penanggulangan penyebaran COVID-19 pada 30 Maret 2020. Kurang lebih hampir sebanyak 35.000 lebih narapidana dan anak telah dibebaskan. Pembebasan itu dilakukan dalam rangka mengurangi overcrowded di lapas dan sampai saat ini itu adalah sebagai salah satu bentuk respon cepat tanggap terhadap penyebaran pandemi COVID-19 di seluruh dunia tentunya khususnya di Indonesia. Diharapkan dengan berkurangnya overcrowded di lembaga pemasyarakatan, maka diharapkan berkurangnya terjadinya antara lain terjadinya penyiksaan di dalam lapas itu sendiri. Hal ini juga sejalan dengan himbauan Komisi Tinggi untuk Hak Asasi Manusia dan Subkomite PBB anti penyiksaan dan di mana beberapa negara lain juga melakukan pembebasan terhadap narapidana dalam rangka mengurangi penyebaran COVID-19 antara lain di Iran, di Brazil, dan negara-negara yang lain. Hadirin yang berbahagia, peserta FGD hari ini, tantangan ke depan yang kita hadapi adalah diperlukannya penyusunan indikator mengenai mekanisme pencegahan nasional yang lebih terukur dan terarah serta bagaimana menjadikan pelayanan publik agar berdimensi hak asasi manusia sebagai salah satu rujukan di dalam penyusunan indikator tersebut. Peningkatan aparatur pemerintah dan penegakan hukum yang terkait dengan anti penyiksaan juga diperlukan sampai dengan ke level pengambil kebijakan itu sendiri. Terkait ratifikasi protokol opsional Konvensi menentang penyiksaan, agenda ini telah dimasukkan ke dalam Rencana Aksi Nasional Hak Asasi Manusia periode 2011-2014 atau generasi keempat atau generasi ketiga. Namun masih terdapat kendala dengan pemahaman bagi aparatur penegak hukum. Oleh karena itu, Kementerian Hukum dan Hak Asasi Manusia melibatkan lembaga penegak hukum lain untuk mensosialisasikan konvensi anti penyiksaan. Di sisi lain, alasan utama pemerintah Republik Indonesia masih mempertimbangkan untuk meratifikasi OPCAT ini dengan melakukan deklarasi maupun reservasi terhadap pasal 20 dan 30 konvensi menentang penyiksaan, yaitu bahwa masih diperlukannya penyamaan persepsi bagi semua pemangku kepentingan terkait mengenai mekanisme pencegahan nasional dimaksud. Oleh karena itu, kita harus duduk bersama dengan semua pihak dan diperlukan komitmen bersama antar kementerian lembaga untuk mengkaji OPCAT tersebut. Bapak Ibu yang saya hormati, izinkan saya pada kesempatan ini menyampaikan apresiasi kepada Komisi Nasional Hak Asasi Manusia yang senantiasa terus mendukung pemerintah dalam menerapkan pencegahan penyiksaan di semua lini. Hal ini diharapkan dapat disinergikan dengan program prioritas pemerintah pada pencegahan penyiksaan. Tentunya untuk menciptakan agar kemanusiaan yang adil dan beradab bagi seluruh masyarakat Indonesia. Bersama ini saya mengajak segenap pihak, baik dari pemerintah, aparat penegak hukum, masyarakat sipil atau LSM, praktisi hukum, dan akademisi untuk terus menanamkan pendekatan berdimensi hak asasi manusia dalam setiap perumusan program atau kebijakan, utamanya mengenai pencegahan penyiksaan. Terima kasih atas partisipasi Bapak Ibu semua. Demikian keynote atau yang pidato kunci Menteri Hukum dan Hak Asasi Manusia yang bisa saya sampaikan hari ini oleh saya, Direktur Jenderal Hak Asasi Manusia. Terima kasih. Billahi taufik wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Selamat sore. Di mute.
Tidak kedengaran.
Good afternoon. MC, have you passed it over to me? We cannot hear you.
All right. I'm so sorry for the mic. And thank you, Mr. Mualimin Abdi, for the keynote speech. Ladies and gentlemen, before we going to the next sessions, we will have a photo session with keynote speaker and resource person. For Mr. Febrian Arudiat, Mr. Mualimin Abdi, Mr. Ahmad Taufan Damanik, Mrs. Sandrayati Moniaga, Mrs. Zazira Zawawi, and Mr. Gerald Joseph. Please turn on your camera on Zoom and smile. All right. with Mr. Anton Prajasto. All right. 1, 2, 3. Smile. 1, 2, 3. Smile. Once again. 1, 2, and 3. Smile. Thank you so much, sir and madam. Well, Excellencies, participants, ladies and gentlemen, to continue our next agenda, I would like to invite Mr. Gerald Joseph to moderate and lead the discussion sessions for international seminar. So, ladies and gentlemen, please welcome Mr. Gerald Joseph. The floor is yours, sir. Thank you.
Thank you to our Miss MC, and good afternoon from Malaysia. Thank you for the invitation to discuss on a very important topic. I think most of us will think, is there really a need to discuss on torture prevention? Because torture prevention should be natural in all our lives. We don't allow anyone to torture us, so we hope we also don't torture anyone. So, but thank you, and it's good to be with, first of all, to our colleagues and friends, Pak Taufan, the Chairman, Commissioner of Komnas, to Commissioner Sandra Moniaga, to the Deputy Minister, His Excellency Febrian, to the Director General of the Human Rights Department, Dr. Mualamin, and to our panel speaker for today, apart from Sandra, is Ms. Shazira Sawawi. I think we are very happy to have a good collection. I think I'm a little bit jealous. I'm coming from Malaysia after listening to two presentations by, three actually, by Komnas, by the Ministry of Foreign Affairs and Ministry of Human Rights. I think that's what ASEAN should have at all levels. Anti-torture should be embedded. So congratulations to Indonesia for leading the way. We're really happy that we have our neighbor who will inspire and help all of ASEAN to move in that direction. We've also found out in ASEAN, I think Dr. Molamin mentioned about the UN Convention Against Torture. Malaysia, Myanmar, Singapore, and Brunei have not ratified. Brunei has signed, I think, in 2016. So I think our colleagues, Myanmar Human Rights Commission and Malaysian Human Rights Commission, we should have some joint collaboration on pushing this UN CAT ratification. I think CTI, the Convention on Torture Initiative, is hoping for universal ratification. So let's work together that ASEAN will be part of that good results. Thank you to His Excellency, the Deputy Minister, and to Pak Taufan for saying that the law must embed anti-torture elements to ensure no way of torture at all levels. You need to work with all governments, all commissions on department. I think the MOU is a good example. But also, I think the more practical part that we find it difficult is convincing our enforcement units that there can be other ways of investigation. And sometimes the word interrogation is still used here, I'm sure in your countries also. And I think Dr. Molamin said there are new methods of effective investigation, which are human rights based. I think these are some of the things that we want to invite all of you to reflect today as we start the seminar on national and international initiatives in torture prevention on the panel session. So with me here today, there are two excellent speakers. I will give you a brief introduction. I think they are quite well known. Ms. Sandrayati Moniaga, better known as Ibu Sandra, she's been a commissioner since 2012. She's taken many parts. She's been vice chairperson for external affairs, commissioner for research and assessment, coordinator on torture prevention, human rights defenders, and even there was an ad hoc team which she was a vice chair on gross human rights violation in Papua. I think she also has a background in the PhD researcher for many years in from Netherlands. So I think we welcome you and good to have you to share with us. Together with you, we also have another very experienced anti-torture campaigner, and I'm happy to say that Suhakam, the Human Rights Commission of Malaysia, had one part of her life with us, I think many years ago, when she was a staff in Suhakam as a human rights education officer. Then she moved on to join the United Nations High Commission for Refugees, UNHCR, in Kuala Lumpur as a senior protection assistant, before joining Association for Prevention of Torture, APT. Everybody's using the word APT. It's a very old, effective organization globally who's been shouting and calling out against torture for decades. I think ambassadors who have worked in Geneva would know APT as very common to stand out. So now she is currently the senior advisor for APT, and I think her big work is on the work of APT's digitalization strategies, and to also move towards multidisciplinary and evidence-based narratives for torture prevention. So welcome to both excellent speakers here with us today. I think the format of today's discussion is each speaker will be given a maximum of 20 minutes. And at 15 minutes, I will have to come in to remind you all there's 5 minutes left. And then after the two speakers complete their presentations, and then we will have about 40 minutes, an open discussion with colleagues. I think I see about 110 participants in our group. So please feel free to you can start putting comments and questions on the chat box. We will try to reflect that and get the two panelists to respond to that. So without taking any more time, it's my great pleasure to invite Commissioner of Komnas, Mrs. Sandriati Moniaga, to take the floor. Over to you, Ms. Sandra.
Thank you, Commissioner Gerald. Selamat siang, good afternoon, ladies and gentlemen, Excellencies, our chairperson, Taufan Damanik, Pak Taufan, from Komnas HAM, Excellency Mr. Febrian Rudiat, the Director General for Multilateral of the Ministry of Foreign Affairs, Pak Mualimin, yang terhormat Dirjen HAM, Director General for Human Rights from the Ministry of Human Rights and Law, Excellency Chairperson and Commissioners from Suhakam, CHRP, from National Human Rights Commission of Thailand, Myanmar National Human Rights Commission, and also Provedor for Human Rights and Justice of East Timor, and a distinguished colleague from Komnas Perempuan, Ombudsman of the Republic of Indonesia, Witness and Victim Protection Agency, and also the Commission for Child Right Protection of Indonesia, and all participants that I can mention one by one. And of course, my dear Sajira, as the other resource person. Allow me to use PowerPoint, Pak Gerald. Okay. Can you see? Yeah. I think I'm lucky that Pak Taufan already started mentioning some of the work of in Indonesia, so I may skip some of the slides. Yeah. So my role is to share with all of you, Excellencies, about torture prevention lesson learned from Indonesia. As you can see, there are 5 logos from the 5 institutions which collaborate to work on this initiative. So torture eradication is a commitment. As you all know that the torture is a direct attack to civilization and humanity. It is as part of international community, Indonesia, just a second. Indonesia aims to contribute in torture prevention. The keynote speakers earlier mentioned that Indonesia has ratified conventions against torture in 1998, and we've been cultivate the culture of human rights in Indonesia, both horizontally within the society and also vertically between the individuals and the state. So what are the means to eradicate torture? Well, the first one, we believe that criminalize the act of torture is one of the way to eradicate torture. Director General Rudyard, Febrian Rudyard, mentioned about the effort of the government to include the act of torture in the process of the revision of our penal code. So a strategy to create a deterrence effect, aside from the international erga omnes obligation, this is important to make sure that act of torture is classified as a criminal act. The process is still ongoing with the drafting of a criminal law, and it aims to provide better protection to individual potential to be victim of the torture. Secondly, we believe that investigate is another means to eradicate torture. So every act of torture has to be investigated to bring the perpetrator to judicial process. And the third one is to increase public awareness and capacity building for all relevant parties. So I think Pak Taufan mentioned about some of the legal protection, some of the laws that provide the basis for freedom from torture for all people in Indonesia. So I will skip this part now. The other is we believe that a cooperation for torture prevention as the approach we use by Komnas and the 4 other institutions. So the principle is prevention, and the second is a constructive dialogue. The prevention effort is to create conditions that leads to non-recurrence of torture and ill treatment. Understanding that the pattern of the act and the environment that allows the act to exist. And this is an important thing for us so that we can prevent the torture happen. And then secondly, constructive dialogue. We believe a good dialogue without shaming and with the principle of two-way direction and equal position can be a effective way to make sure that the torture prevention mechanism can be established in this country. So what are the strategies for prevention? First is the visit of places of detentions. And the second is fact-finding to make evidence-based report and offer practical recommendation. And then the third is to develop the same comprehension of torture and ill treatment. And then lastly is most important to develop trust, transparency, and accountability habits. Now, what is the opportunity to establish national preventive mechanism? As mentioned, there are 2 UN approach. One is the CAT, or Conventions Against Torture, which use more repressive approach. And the second is OPCAT, which is more on preventive and emphasize on prevention, putting forward cooperation, and dialogue. So what are the pillars of OPCAT? OPCAT has 2 pillars. The first pillar is on the UN Subcommittee for Torture, or SPT, and the second is the National Prevention Mechanism. Now, what is the opportunity? For us in Indonesia, having national preventive mechanism is a national interest. After 12 years of ratification of CAT, or Conventions Against Torture, the torture exists. So we think and that there's something serious there. So we think that this NPM can be an approach to prevent torture because it's emphasized on dialogue than shaming. For Indonesia, it is important to always have dialogue, musyawarah, mufakat. That's one of the principles in our Pancasila. Second is about endorsement. We've got good support, as Pak Gerald noticed. Endorsement from ministries, Ministry of Foreign Affairs, Ministry of Human Rights and Law, and also Ministry of Social Affairs, who also responsible for some places where you have people with mental disability is being taken care. And also we get support from other state institutions. In addition, we also have vibrant civil society and press freedom. Some also indicative political will for commutation of death penalty, wide space for dialogue, openness and cooperation of government institutions, and we also get good international support from EU, APT, and some UN institutions. But what are the challenges? If we have a conducive situation, but why it's not that smooth? One of the serious things, torture has been seen as an iceberg phenomenon. It's systemic nature of torture, where you have so-called culture where torture is so common. A long detention before a suspect brought to justice is also another problem that provide another possibility to face some torture. So the culture of violence also among law enforcement agencies, like Gerald mentioned, uneven comprehension of torture, ill treatment and torture prevention, and variety of a large number of detention places. So what are the role of KUPP, or Kerjasama untuk Pencegahan Penyiksaan, a cooperation for torture prevention, which mentioned before by our chairperson, Pak Taufan, and also by Pak Gerald. It is a joint initiative of 5 institutions. It's been mentioned. This one, the logo we need to have. And we've been working since 2016, but then a more effective work has been taken place since 2018. 2019 actually, since we have full-time staff and also support from several institutions. What are the works? So internally, we have a more coordination among the 5 institutions. We met before this pandemic, COVID pandemic, we met every month, coordinate the work, make a joint plan of activities, evaluate, and also do several things together. And then we also jointly developed monitoring tools and guidelines. It was supported also by APT to develop this monitoring tools and guideline, but then we adopted to our Indonesian situation. And then we also conduct capacity building for more than 25 staff at the national and local office. Recently, we have an online training for staff from of the Komnas and Ombudsman representative office in the provinces. So what about other works? Externally, these 5 institutions have been collaborate with Directorate General of Corrections and Director General of Immigration, and looking forward to have the same Memorandum of Understanding with the Indonesian National Police and Ministry of Social Affairs. We have also conduct unnoticed visit and notice visit, and gladly we get also endorsement from Ministry of Foreign Affairs. Thank you, Pak Febrian, and also Ministry of Social Affairs to endorse the ratification of OPCAT, which we have to do some follow-up activities. And then this KUPP also developed constructive dialogue with the government agencies, and we are in the process to carry out training for staff of the Director General of Corrections, especially the prison staff. So these are some photos of the activities and joint publication. I think that is all, Pak Gerald.
Thank you.
I
Thank you.
hope on time.
Yes, very much in time. Thank you, Commissioner Sandra. A big hand for you. I know you can't hear us, but we are all there. Thank you for outlining the framework, the philosophy, and also the practical approach in bringing this anti-torture message and protection mechanism in the country. I think you started off by talking about the word civilization and humanity, and then you brought it to how the first instant is whether a country wants to criminalize act of torture, then to investigate if there's torture, but also there's two levels. One is working with the government, the state, and one is with society. I think we still have a long way to go to even convince our friends, our family members that torture is no. There is no a little bit of torture allowed, and big cannot. It's black and white, no to torture. So congratulations for Indonesian people, Komnas government for not giving up on keep trying. From UNCAT to OPCAT. And also for the humility in acknowledging it's a work in progress, because after 12 years of ratification, you're still struggling. And I think the spirit is that we're finding all ways to move a society to move away from this torture. I think you acknowledge that it's like the iceberg phenomena. It looks easy, but the undoing what can be seen is difficult. I think you have given ample reason how an international framework called the UNCAT actually helps develop your own internal mechanism, because all your stories is about internal, of course, created or inspired by an international framework. I think the main work, and that's congratulations to the people of Indonesia for doing it as an internal part of your value building and the soul of your society. So thank you again for that. As I hear you, I'm waiting for that one day where all ASEAN can speak with that voice. We are getting there. Thank you, Commissioner Sandra. And now we continue with another colleague who comes from the same region, but we have sent her to be in Europe now. She's in Switzerland, doing great work there. So it's over to you now, Ms. Shazira Zawawi, the Senior Researcher and Advisor of APT.
Thank you very much, Gerald, for the introduction. And it's really nice to see you again, an old friend since the Komnas days. And I'm always happy to be in a CNF event, because it always reminds me of where I started as an officer with Suhakam, and seeing familiar faces, and I think people who are really doing a lot of important work in torture prevention. And I'm just amazed with the spirit and the commitment and also the energy to keep continuing this important work despite the challenging time at the moment. So I think all of us, especially members of CNF, and I believe everyone who is listening now, should pat each other's back and say thank you for all the good work. And as Gerald say, we have to continue. So thank you very much to Pak Fabrian, Pak Muamilin, Pak Taufan, Ibu Sandra, as well as the chairpersons, the commissioners and the staff from all the initial rise in the CNF forum for having me today in this event. And I will just continue from where Ibu Sandra started. There's a lot of really good things have been said in the speeches made by Pak Muhammadin, by Pak Fabian, by Ibu Sandra. So I'm here maybe just to highlight some of the other aspects from my observation as well as my work in other parts of the world. So for my presentation today, I would like to focus on three things. First is where we are at the moment with torture prevention, perhaps a bit of development in the world, as well as maybe some observations from the region. I think it's also important to perhaps have a look at how torture prevention works in terms of COVID, because I believe oversight bodies, especially NHRIs, are having a lot of challenges to continue your work, especially conducting visits, and perhaps a bit of reflection on how we can move ahead, especially during this challenging time. Just to know whether the presentation is clear enough or big enough, the shot.
Very sophisticated.
Trust me, I just tried this out. So if anything happened,
very
my
impressive,
apologies.
very impressive.
My apologies if anything, goes wrong. Okay, so let's have a look at what's going on in the world today. So as has been mentioned before, at the moment, we have 171 state parties to the Convention Against Torture. I'm happy to say that over the last 1 year or so, a lot of the state parties come from the Caribbean islands, interestingly. We have not received any news about any ratification from the Southeast Asian region yet for the last 1 year. And then on top of that, we have 19 state parties to the optional protocol to the Convention Against Torture. And out of these 90 state parties, 74 of the countries have designated a national preventive mechanism. And out of the 74, 14 are NHRIs. Now, those who are not NHRI, normally they are either Ombuds Office, NGOs, or new institutions that the government established to fulfill their obligation under the OPCAT. Now, I'm very, very happy to hear about the investigative interviewing or the new technique of interviewing that's been mentioned in the speech before me, because that's another development that I would like to share at the international level, because at the moment, since 2017, we have been working together with a number of experts, human rights experts, as well as law enforcement and practitioners, in developing a universal guideline on effective interviewing. So now they're trying to use the term effective interviewing, no longer investigative or investigation, effective interviewing. The work has started in 2017. They're still finalizing the content, but hopefully this guideline will be adopted in the UN sometime next year. So I think this will be a very useful reference point for NHRIs who are interested to perhaps even invite experts who are working on the guidelines to be part of your national work, or even using the guidelines to be integrated into your training or your awareness raising. But do check out our website and also our social media to receive latest developments about this international standard. It's also interesting that over the last few years, there's a lot of research done on torture. And this research is also, it's not just legal, it's very much multidisciplinary. So you can see from the perspective of neuroscience, national practices, and even the latest, I think, by two researchers from the US on the media portrayal of torture. And this research, I think, is very crucial in terms of helping us shape and understand public acceptance or public opinion on torture, and also why people still resort to the use of torture by the law enforcement. I give you an example of national practices. So the APT conducted a research in 16 countries over the course of 10 years. This research has been led by Richard Carver. And from that research, which focuses on national practices, we found that the highest risk of torture is during the first hour of police custody. This is where it's the highest. Yes, torture can happen in prisons due to overcrowding, due to lack of, capacity building of the officers, but the highest risk actually occur during the first hour of police custody. And one of the most effective measures to address this is, of course, the effective implementation of safeguards. And what are the safeguards? We found that the safeguards here include information about rights. The more the arrestee know their rights, the better they are at understanding what they're going through. And then the next one is notification of families of the arrests, access to lawyer, access to medical treatment or doctors. These are some of the safeguards that we found are really, really effective in curbing risk of torture during the first hours of custody. And in some instances, but this is not widespread yet, is also the installation of CCTV in the police stations. I do believe that some countries in the region has already been doing it, but it also begs other questions of how it's been implemented and how effective it is as well. But I think it's a first step towards working on prevention of torture. And then if you go to the region, which I think the interesting thing about the region, and I love Southeast Asia a lot, is that there's a lot of things going on. There's a lot of efforts going on. And it's just a matter of us talking to each other, helping each other, working together, I think. In 2017, for instance, one of the interesting and I think very, very important initiatives started by the CNF is the CNF guideline. It's still, I think, in the process of deliberation and maybe revisiting the content, but it's a very good start for the CNF members to work together to combine your resources and understanding of torture prevention and putting it into a guidance that can be used by everyone. So I think that is a very, very useful practice and activity. HR, as Indonesia is continually leading the torture prevention as one of its thematic issue. I believe there will be an event coming up soon as well on this sometime soon. And I think Indonesia's role in leading the discourse on torture prevention in the region is very important, as well as being part of the Convention Against Torture initiative. I just want to give a snapshot in terms of national maybe national practices and also context here. So as we mentioned before, we have 6 UNCAT parties. Brunei has signed. I was in Brunei last year. There's certainly some efforts going on to sort of build a better commitment and understanding of what ratification means. We have 2 UNCAT parties so far, 2 anti-torture laws, which is the Philippines and Timor-Leste. And then we have 2 de facto NPMs. De facto here because the government itself has not formalized the designation. But on top of that, we have ongoing processes. We have what's going on in Malaysia with the campaign for ratification. We have in Indonesia, the platform to continue the work with the NPMs towards advocacy for ratification. In Thailand, we also have the continuing work on the anti-torture law. They're also looking into having a separate legislation for anti-torture law. So these are all ongoing processes that I think makes the region very dynamic when it comes to torture prevention. So the next one is, I think I have to talk about COVID-19 because we are in the pandemic and it is affecting our work, especially torture prevention. And so just a bit of a highlights of some of the scenarios that we are discovering or identifying with our work with our partners. The COVID-19, we see, overcrowding has always been an issue in prisons. As you can see, I think there was an estimation by the Penal Reform International that by the end of 2019, there are 77 million people in prison and another 3 million in pretrial detention. And then if we look at another estimation, by 5th of November 2020, there's about 283,332 prisoners contracting COVID-19 across 111 countries. And 2,537 prisoners in 39 countries have died. So just to give you a glimpse of how prisons are the hotspot for COVID-19 due to the nature of the detention places, the overcrowding, the congestion. And because of this, one of the interesting scenario is we were seeing a lot of release of prisoners. As mentioned in the speech before as well, about how Indonesia is part of this effort to release prisoners from the prison. We see in the region, the Philippines are also taking steps towards releasing prisoners. I hear some news that it's also taking place in Myanmar. So there are efforts to release prisoners from the prison due to the current COVID-19 situation. And I think this is also important to contribute to the whole discussion of torture prevention, because we expect that with this measure, it means reducing and decongesting the prison and also ensuring a better quality of the prison conditions. But it also begs the next question about what it means for reintegration of the prisoners in society. What about the level of recidivism? And what about society's acceptance or view about the release of prisoners as a whole? This is a very, very good measure, as you can see, but I think it's a very interesting phenomena that I think worth discussing when we talk about torture prevention. At the same time, interestingly, detention places remain overcrowded in some parts of the world, and this is due to the restrictive legislations or implementations of laws to curb COVID-19, which leads to a lot of those who breach these measures to be imprisoned. So it's a bit contradicting to the first scenario. And this also begs the question of, again, to my next point about, you know, how we view these emergency measures in light of suspension or abuse of rights. The next point that I want to mention, which is another scenario of the COVID-19 that worth discussing and observing, is discrimination against minorities. Now, we know for sure that this is an ongoing situation, that all of us are trying to work in changing it. But we see how it's been amplified during the COVID-19. We see the treatment of migrants, the treatment of minority communities in the society being stigmatized or targeted as the cause of COVID-19 contraction or infection. So this is another scenario that I felt part of the bigger discussion that we have to have about, you know, the root causes. We talk about the iceberg just now, which I think is very interesting. So we see the torture as an iceberg, but actually beneath it is all the root causes, all the systemic discrimination, all the issues that contributes to what's on top, and this needs to be dealt with. And I mentioned here isolation and exclusion because in addition to prisons, we also look at detention places like psychiatric institutions.
Excuse me, Shazira.
Sorry.
You got 5 minutes more. No, 5 minutes
Sorry,
more. Just
okay.
thank you.
Okay, thank you for the reminder. I'll try to be quick. Isolation and exclusion, I think here refers to the situation in psychiatric institutions, old folks' home, and long-term care facilities, because their contact with the outside world have been severed during the COVID-19, and this leads to very severe cases of isolation and exclusion. Now, just to sum up some of the things that we see with the work and role of NSRIs. First, we noticed that suspension of visits to detention places might happen to some of the NSRIs because of the situation, but we also see how NSRIs are gradually adapting to the pandemic. We also see how detention places visited are being reprioritized because of resources, because of the situation, because of maintaining security. So for instance, at this point of time, quarantine places are also considered as detention places and being visited by NHRIs. So I think this is some of the changes that happened because of the pandemic. And also, of course, the emerging use of technology. For example, we see how NHRIs or NPMs in New Zealand, in UK, are using technology for remote visits or remote detention monitoring. So I'll just go to the last my last slide of the day, which I hope we can discuss in the question. I just want to keep everyone's spirit up. The torture prevention movement needs you. Of course, it needs the NHRI, it needs the oversight bodies, but also it needs all the other actors. And I think it's time we in the region start talking to each other, start supporting and it's already starting, definitely. But I think we need to continue the momentum and the spirit. And that's why I really appreciate the fact that Komnas HAM is having this side event. Second, sustaining oversight is key, no matter what, even if the pandemic is on, even if the pandemic is over, the role of oversight body to assess detention places are important. As you can see, there's a lot of things happening during the COVID-19. The conditions of detention are deteriorating, riots in the detention places, and this is why oversight body needs to assess detention places. What are the new norms for preventing torture? Now, the pandemic totally changed everything, including what we understood as preventing torture to a certain extent. So what are the discussions that we can have on what are the new norms? For instance, the non-custodial measures, release of prisoners, how do we deal with it? And we're at the APT are also promoting more transparency with information. We have a lot of information bombarding us during this time. How do we systematize information and use it to push for a more comprehensive arguments for torture prevention? Last but not least, I love the fact that, in this time we also see kindness, we also see people supporting each other. And in torture prevention, I think we need to maybe try a bit more to push for a more hope-based narrative, to inspire people that the work needs to be done and needs to be continued. While it's important to state and name the problem, while it's important to identify the issues, let's push for a more hope-based narrative so that everyone will be part of this effort. Thank you. That's all from me.
Okay, thank you, Shazira. We were trying to unmute the button. You're missing the button, but excellent presentation. Thank you for bringing home both reality and continuous efforts at the global level, both in ASEAN and other parts of the world. I think you give note to this whole effective interviewing. I think that's in the first few hours is where the danger is, the risk. I think that's for all of us. Society needs to know if we can prevent the first few hours, we probably will reduce the big risk by a lot. I think the other part, the work of NHRIs, as you framed it, is very clear. But I think the larger part of society, that one of the biggest safeguards are info on rights. I mean, many people wouldn't know what to do when the policeman stops you. It's really half and half. We just pass message and say you can, you cannot. And so a lot of work to be done in all of societies. Notification of family, arrests, lawyers, CCTV, proud to announce the Malaysian government has started CCTV in all lockups a long time ago. But sadly, the budget for ensuring that it works after it's broken down is not there. So it's actually linked to money for budgets for prevention of torture. I think is important. We need to put money into that. I think, thank you for the reminder. CNF, for friends who have joined us as participants, this is actually, this side event is actually done on the sidelines of the 17th Annual Conference of the Southeast Asia NHRI Forum, which we call SEANF, in short CNF. So we hope CNF can also come up and complete our work on the guidelines on torture prevention. I think it will be discussed on the agenda item. I think you also brought us to realize, thanks for that stark reminder of the numbers, the 283,000 prisoners with COVID-19. And I don't know if I couldn't get the number, but I thought a huge number of prisoners also died from COVID. Because the best intentions to make sure social or physical distancing and all health protocols are really difficult to implement if overcrowding happens. So the good news is, I think Indonesia, we heard the government mentioned just now the early release of prisoners. You said Myanmar. In Malaysia also, the prison department is using existing law before, not it's there, but now using it much more. And Suhakam, the Human Rights Commission, have been pushing for a rethink of how to decrease the overcrowding, because there are segments of the population of prison could be to drug abuse. I think about 40% drug abuse. So if we have a different way of managing drug abuse, maybe a big decrease. Immigration offenses, it's an administrative offense, but they're also in the penal system. So questions on how to decrease that is an important point. But thanks for pointing out minorities get it differently at this point, vulnerability. And also COVID has actually brought us to a different way of working. Because I think this is something that I picked up also, even quarantine for health. NHRI should visit to check whether the Ministry of Health quarantine facilities comply with minimum standards, if you're locked up and you cannot move. But this is something we will reflect. But thanks for ending on a message of hope that we have to think broader, root cause, push for transparency of information. I think this is what we mentioned also more recently in our press conference last week, Suhakam, that maybe now is the best time to ask the root cause questions on how we manage our detention facilities. This probably is a good time for us. Since anyway, we have so much time for so many online discussions, let's add on a few more. But thank you very much, Shazira, for that good presentation. So Shazira and Commissioner Sandra, two very good presentations to keep Asia, ASEAN people thinking and reflecting. And I think I've opened the discussion space now. The format is you can write in the chat box, or you can also raise your hand in the participants. There's a raise hand function, as you probably are now experts in Zoom. If I recognize you, I will invite you to click the participant box. Yeah. Okay, so while waiting for the raise, there is one raise hand. Okay, there is a question. Oh, I'm noticing it's from one of our staff members. I will invite Aida to ask the question. Host, can you allow Aida to ask the question? Host, Komnas, can you allow Aida to ask the question, please? Aida, can you ask the question, please? Unmute yourself, Aida. I don't think Aida is hearing us. Okay, there's another hand raised also there. I see another hand raised person. The Myanmar National Human Rights Commission. Can I invite the Myanmar National Human Rights Commission? Did you want to ask a question or make a comment? Yes, Myanmar National Human Rights Commission. Can I invite you to please make your comment or ask your question? Thank you.
Hello, I hope you hear me. You hear me?
Yes, we can hear you, Commissioner. Person, please go ahead.
I'm from the Myanmar National Human Rights Commission. First, I'd like to say that we appreciate it very much that we have this seminar on preventive measures against torture. It's a very useful seminar, we think, a very timely one, because at the present time, Myanmar is in the process of to become a state party to UNCG. MNHR is working on it very diligently, but we do not know how long the process will be. But at the same time, I'd like to inform that there are anti-torture provisions in Myanmar Constitution as well as in the Penal Code. On the other hand, the society does not accept any acts of torture. It's a good thing. But even then, we still have certain instances of torture acts happening. And we are receiving complaints in the MNHRC, and we are handling them. So now, although we know that there are certain measures that can be taken to prevent torture, like effective and deterrent punishment of the perpetrators, and like enhanced awareness among the law enforcement authorities are effective. But what I want to know is now, the Myanmar case is very strange because although we have certain provision against torture, these acts are happening. So my question is addressed to Commissioner Sandra. We have learned a lot of lessons from Indonesia. Now Indonesia is setting a good example in the region. What, in your view, is the best and most effective measure to prevent acts of torture before Myanmar has a more effective legal framework against torture in place? Because we are like in gray area now. Although we are provision against torture, but torture is happening. Now we haven't become a party to the UNCT. We have to wait for some time to become a party to it. So in the meantime, what we should do to prevent the happening of torture acts in the country? I'd like to hear from you. Thank you very much.
Thank you. Thank you, Chairperson, Commissioner from Myanmar Human Rights Commission for that question. How to prevent the acts of torture while we still don't have the UN CAT yet? What can be done? Because they are trying, but it's still happening. And I think I would also add in the Malaysian experience to ask that question through the Myanmar question. Yeah, it's directed to Sandra, but I think I will just pick up another two. Just open the chat. And then we can, So there was another question by Andrew. Can you, by Andrew Koo. I think you can read it, but I'll read it for the rest of Malaysia and French government's new law regulation that recording police at work and viraling it will now be an offense. Okay, context to those who are present. Recently, there was an arrest of a student or a youth from an organization. And while the police was going to arrest him, another person was recording it on camera, and that person was arrested and now being charged for viraling it and is saying it's impacting the effective work of police investigation. So is that an offense? Number two, Malaysian police will start using body cams from next year. I think that's a statement. And then I have another, so that's for Shazira. And the third question, and with this we'll stop and give it back to the panel members. This for Indonesia. Did Komnas think that law enforcement had fulfilled its obligation in the torture prevention, since there's still many cases where law enforcers does doing torture on criminal suspect in order to get their confession, I think, and such thing was not investigated either by the provisional government or provisional laws or other law. I think this was admitted by Commissioner Sandra. Reality on the ground is different. So, but how do we probably move forward? This probably could be taken up also by both of you. So thank you, friends. You can keep raising your hand or write the question in the chat box and we will pick it up and let you let the panelists answer. So maybe Commissioner Sandra, you can make some brief comments on the questions directed to you. Sandra?
Thank you, Commissioner Gerald. Thank you, Excellency Chairperson from Myanmar. What we did in Indonesia was we started several things for the National Commission on Human Rights. We document the torture. Yeah, we monitor the cases and then document. And then secondly, we did lobby in early 90s after Komnas HAM was established, collaborative effort between Komnas HAM, civil society, and lobbying political party to support the ratification of the conventions against torture. So that was happened in 1998, yeah, the ratification. But at the same time, we worked on the Indonesian laws and regulation. So after Suharto stepped down, there was an amendment of the constitution, and we succeeded to have human rights principles in the articles of the constitution. So as I explained earlier, there are several laws that can mention about prevention of torture, that everybody is freedom from torture is in the constitution, in the human right law, and also a few others law. And what interesting also in Indonesia, the police make an internal circular. There is a police chief regulation explaining about human rights principles for implementing their work, and the same time with the military. These are just the legal framework, but it doesn't guarantee that it will be implemented. So the next step is to engage with dialogue. So this is what we learned from the NPM, the OPCAT, the principle of constructive dialogue. Keep moving on the dialogue with the parties. Continue, talk to them, and then explain and remind them about the rules and the regulation. So that is what we try to do. And so far, positive response, but it's not easy to change the culture of violence. Yeah? So that come to the second questions. As I mentioned in my presentation earlier, no, we don't think that all law enforcement agents apparatus really already consistent with the law. No, not yet. But there are some good people who try to really comply with the rules and regulation. But as you know, torture is not formulated in the in the penal code yet. But we just use some of the possible or relevant laws and regulation. But it's not maximum. It's still far from ideal, but we still have to continue work and engage with constructive dialogue, involved with education for the police member and also other state apparatus. Thank you, Commissioner Gerald.
Thank you for that response. Over to you, Shazira.
Thank you, Andrew, for your question. I think I understand your question as, is it an offense for someone who records an action of the police and viral it, and then be arrested for doing so? Is that correct? I think the more fundamental question that I want to ask here is why? Why people are actually recording and viraling these videos of misconduct. In a lot of contexts, the reasons is because by doing so, they're actually getting an attention for an issue that is very important in society. We see how videos go viral in the US context and how it's fueling the national debate about racism and policing. So I think that the more important question is, why do people actually record these videos and then make it go viral? I don't think these people should be arrested. That's my personal view. It's not APT's view. I don't think these people should be arrested. And I think the law enforcement should actually look into the scenario and the issue, why people are viraling these videos and putting it online. And then maybe, because a lot of this is also a manifestation that the system is not working. If they are, one, aware of their rights and what to do, and two, they get the right response from the police or the opportunity to engage the police in a more effective way, I'm sure that people will not, succumb or use such tactic to get the issue that they report getting the attention it needed. So I think, it's quite a viral culture is quite a culture that's happening around the world at the moment.
Thank you, Shazira. There's we captured 2 more questions. This is from Ria SBMI to all panelists. Untuk pencegahan penyiksaan ini, apakah juga berlaku di negara Arab Saudi? Kerana masih sangat banyak sekali buruh migran yang mendapatkan siksaan dari majikan maupun agensi di negara Arab Saudi. This is a global picture. Maybe APT can answer, or Sandra. And also, that's your translation, is it? Okay, and then and I think I would also invite the commissioner from the National Human Rights Commission of Thailand to ask a question or make a comment. But can I request to make it very brief and short because we have very little time, and then the translator, the interpreter, will help translate to English. Thank you. Can I invite the commissioner from Thailand, please?
Commissioner Joseph. Phil.
Hello. Commission from Thailand, NHRCT. Please, you can speak now. Mute, maybe the mic is not on. Mr. Ponchai.
Okay.
Yeah.
สวัสดีค่ะ ดิฉันนางสาวอารีวรรณจันทร์ทองค่ะ ทำหน้าที่เป็นกรรมการสิทธิมนุษยชนแห่งชาติค่ะ ก่อนอื่นเลยนะคะ ขอขอบคุณนะคะ ท่านคอมมิชชั่นโจเซฟและท่านคอมมิชเนอร์นะคะจากประเทศต่างๆ ท่านวิทยากรทุกท่าน ท่านประธานและกรรมการของสมาชิก CNF นะคะและผู้เข้าร่วมการประชุมทุกท่านค่ะ
Good afternoon, Chairperson, panelists, Chairperson, Commissioner of all CNF member and CNF colleagues. Here with me, Commissioner Ariwan Chatutong. She would like to thank to all panelists and Komnasam and Suhakam that host today for us the webinar on national and international initiative on torture prevention.
ดิฉันจะขอนำเรียนแลกเปลี่ยนข้อมูลนะคะหรือความคิดเห็นที่เกี่ยวข้องของประเทศไทยนะคะ
The NHRCT would like to share our update to the meeting today.
ปัจจุบันนี้นะคะประเทศไทยของเรานะคะก็เป็นหนึ่งในประเทศในภูมิภาคนะคะที่มีความก้าวหน้าในเรื่องของการป้องกันการทรมาน
Recently, Thailand is one of the countries in the region that has made advance in the torture prevention issue.
โดยทางที่เป็นของไทยนะคะเพิ่งจะให้ความเห็นชอบนะคะในส่วนของร่างพระราชบัญญัติป้องกันและปราบปรามการทรมานและการกระทำให้บุคคลสูญหายไปเมื่อวันที่ 23 มิถุนายนที่ผ่านมา
The Thai Council of Ministers has recently approved the draft Act on Prevention and Suppression of Torture and Enforced Disappearance on 23rd June 2020.
โดยตัวร่างกฎหมายฉบับนี้นะคะก็จะมีเนื้อหาที่เน้นในเรื่องของการมีมาตรการนะคะป้องกันปราบปรามและเยียวยานะคะเพื่อคุ้มครองสิทธิของทุกคนที่จะถูกกระทำโดยเจ้าหน้าที่ของรัฐค่ะ
This law will focus on preventive and suppressive and remedial measures to protect the right of all people to be treated by government officials.
ซึ่งในตัวร่างกฎหมายฉบับนี้นะคะมีวัตถุประสงค์สำคัญนะคะที่ดิฉันอยากจะนำเสนออยู่3ข้อด้วยกันค่ะ
Its main purpose are
1นะคะก็เป็นลักษณะของการให้ความคุ้มครองบุคคลทุกคนค่ะ จากการกระทำทรมานและการกระทำให้บุคคลสูญหายโดยเจ้าหน้าที่ของรัฐ
Firstly, to protect all persons from torture and disappearance by government officials.
สองคือการเพิ่มประสิทธิภาพในการบังคับใช้กฎหมายเพื่อป้องกันและการปราบปรามค่ะ
Secondly, to increase law enforcement efficiency in prevention and suppression.
สามคือในกฎหมายเนี่ยจะมีเนื้อหาให้รัฐต้องเยียวยาผู้ที่รับความเสียหายจากการกระทำในลักษณะต่างๆ
Thirdly, to remedy those affected by acting of torture and enforce disappearance.
ซึ่งรวมแล้วนะคะก็จะเป็นการขจัดปัญหาการละเมิดชีวิตชนนะคะที่ร้ายแรงเป็นการสร้างหลักประกันความเป็นธรรมให้กับประชาชนค่ะเพื่อแก้ไขปัญหาการกระทำทรมานและการกระทำให้บุคคลสูญหายในประเทศไทย
The draft law also aims to eliminate serious human rights violation and ensure fairness for the people, as well as to address the problem of torture and enforce disappearance.
แล้วก็เป็นการกำหนดความผิดในการกระทำทรมานและการกระทำให้
Commissioner Ariwan, may I request you to wrap up because we don't have time. Thank you.
จบได้ครับ
ซึ่งกสม.ไทยเองนะคะก็มีส่วนสำคัญในการผลักดันตัวร่างกฎหมายฉบับนี้นะคะรวมถึงให้ความเห็นและข้อเสนอแนะในการจัดทำร่างกฎหมายดังกล่าวด้วยนะคะ
In the process of drafting the law, the NSRCT has played an important role in advancing the law by participating in the drafting process and ensure that the provision will comply with international standards.
เพราะว่าเรามองว่ากฎหมายฉบับนี้จะต้องมีคุณกรณีที่เกี่ยวข้องในอนุสัญญาต่อต้านการทรมานและการปฏิบัติหรือการลงโทษที่โหดร้ายไร้คุณธรรมหรือย่ำศักดิ์ศรีหรือที่เรียกกันว่า tax เนี่ยค่ะนำมาเป็นกฎหมายภายในประเทศอย่างเป็นรูปธรรม
The legislature is to concretize obligations under CAT into domestic justice system.
ซึ่งเราเองได้มีส่วนร่วมนะคะกสม.เนี่ยได้มีส่วนร่วมในกระบวนการจัดทำร่างกฎหมายฉบับนี้นะคะเพื่อ
Commissioner Ariwan, I really have to stop you now because we need to give others a chance and many more questions. If I can request that be your last sentence.
Thank you.
We get the point. Thank you very much. Yeah. Thank you very much, Commissioner Ariwan. I think it's a very good congratulations to Thailand and to RCT for pushing the government to have this draft act on prevention and torture and disappearance. Another good example for other countries to follow. So that is an example of how other countries can follow through. I think there also, I will pick up a few other questions from Iftitah Sari. I think she's saying that she or he is saying that studies confirm that torture during police interrogation occurs due to heavy reliance on the dossier during trial investigation paper. So the poor implementation and regulation of fair trial rights under the current criminal procedure code in Indonesia, how do you see the revision of the criminal procedure code can be a significant attempt in preventing torture? So the review. Number two, commutation of death penalty. How will KUPP maintain its commitment in promoting commutation of punishment, particularly for death row inmates who have been detained for decades? So is that through dialogue, through relevant stakeholders? Is that to visit them or independent evaluation? So questions, two questions. And there's another question here. How does the principle of prevention of torture concretely apply in cases of state-sanctioned cases of brutality, such as those committed by security personnel? So I think prevention and torture is across the board, but this is specifically saying if it's state-sanctioned brutality, how is there a different way of handling it compared to just individual officers doing torture or when it's state-sanctioned? Okay, maybe I'll give this over to Shazira first. You can take the floor first, and then I'll give it to Commissioner Sandra.
Hi, Johannes. Thanks for the question. My short answer is, in the definition of torture itself, it doesn't only look at the perpetrator of the act directly, but if it's within the knowledge of the state, that's where the definition of torture also cover actions committed by people who have who receive orders from them, or who are work on behalf of their interests, who are committing the act. Should also be covered by the definition of torture. And if you have such law in a country, the legislation should also cover such act. So torture, the definition of torture in accordance to Convention Against Torture doesn't only look at the direct perpetrator, but there's an element of the chain of command, who's directing it, the elements of acquiescence, the element of state sanction, as you mentioned, is also covered by the definition. That's my my short answer, but be happy to explain further if needed.
Yeah, I think, Shazira, if I take on the question a bit further, I think in the chain of command, usually in the, as was mentioned earlier by the one of the speakers, one of you all, that the police chief has their own internal, I think Commissioner Sandra mentioned, even in Malaysia, the chief of police have very clear instruction. You cannot find any language allowing their personnel to torture. So to find that, you can't find, but tacitly, by not saying many things, it happens. So how do you prevent that part which is not on paper, but there's a culture? I think the example used by yourself, the culture of us, by Commissioner Sandra, the culture of violence, does that also link to this question of, is it considered state-sanctioned brutality, or that culture of violence actually a society culture, so you cannot put it on state? Thank you.
I think you also mentioned it's a culture of violence, which is, I think, the broader problem, no? And torture is a subset of the culture of violence. So if we're talking about culture, I think there's a lot of work needs to be done in terms of how do you train the officers, how do you train the public to, for instance, on an opportunity for them to lodge complaints or to report on incidents that have used. Is there such a complaint mechanism in the public? Is there an openness for the government to receive complaints regarding such cases? So I think it goes beyond the technical definition that I provided earlier. But what is even important is, if you have an anti-torture law, it will also enable you to install all these measures and these policies in place. How do you deal with the secrecy of how torture is committed, for instance? How do you improve transparency and accountability? And how oversight bodies contribute as well to the discussion? So yeah, I agree with you that it's a bit of the culture. How do you actually initiate these measures to open up the possibilities and chances of actually finding, how torture happened? And I think that's part of what torture prevention is. It's about ensuring that we can stop the action to occur, but also the mechanisms that you have to put in place, the practical mechanisms that you have to put in place. And I would say that it's a work in progress for a lot of countries as well. Like, you can have an anti-torture law, but you can still, lack the mechanism for public to complain, or you can have an anti-torture law, but still some oversight bodies are unable to access detention places. So all these, to me, has to come together, and it has to work hand in hand.
Thank you, Shazira. Over to you, Commissioner Sandra.
Thank you, Commissioner Gerald. Allow me to answer first the question from Mr. Johannes Paulus. In my understanding, this prevention of torture is basically for prevention. So to prevent torture happen, and it's a mechanism to prevent the torture. But in the case of state-sanctioned cases of brutality, it's a case. It's a violation. It's different. It's something happened. It's part of the what we call enforcement. It's already applied. So you have to process the person or the apparatus with with the to the judicial process. So it has to be investigate what have been violated, and it shall go. The principle is it has to go through the judicial process. Whoever does any torture, so that is how we can prevent further torture, the future tortures. So that is the answer. And the second is the question from Ms. Tita, I think, yeah, from ICGR. The revision of the KUHAP, we call KUHAP, the Criminal Procedure Code, it's another work of Komnas HAM and other NHRI. We do concern, and we definitely want to make sure that the revision will include human rights principles in the new form of this criminal procedural code. So, but as we all know, it's been postponed until the revision of the penal code finalized. That's what I understand from the parliament member. The second is about the issue of commutation of death penalty. Komnas HAM has been discussing that issue with various parties, but definitely in the legislation process, we've been advocating the abolishment of death penalty. Second is we discuss also with the authority from the Director General of Correction to how to treat the death row, the people who's already penalized. And it's been discussed, we are still trying to find the best way for how to help them, but it is not under their mandate. It is under the Supreme Court or the President's power to cancel or gracie and amnestia for the people who face death penalty. But with the Director General of Correction, it's been discussed on how to treat them better so they won't really, the feeling of torture will reduce. I mean, having faced in the death row is already a torture itself, but how can we help them to reduce that torture happen? So that is my answer, Commissioner Gerald.
Yeah, thank you. Thank you. That's good. I want to pick up two questions together, but I see Mr. Bambang Dahana, hello, saying hello to your Koalisi Buruh Migrant Daulat. He's saying hello to Mr. Gerald Joseph Me, asking questions on whether we have done work on the torture of migrant workers. So since the panel discussion, the panelists are here, I will give you all a chance to make comments first. Maybe this is also linked to the Saudi Arabia question. We've been talking about state officials. I think the migrant worker one has two elements. I think, Bambang, your question is about if in detention, the treatment, does it constitute torture if the conditions are bad, prolonged detention? And so I think that's a good question that Bambang has said, and he said also that Komnas HAM has already sent a mission. So Komnas HAM is doing his work. What should we do to prevent this? But the other question by our colleague Ria, I think, is about non-state actor, employers. She mentioned Saudi, but I'm sure all our countries, we've got examples of a non-state actor, an employer, a domestic helper, or a factory owner, and the conditions. Is that, does that constitute torture? How is that be prevented, or that's criminal? And how do we manage that kind of torture that is not done by state officials? Sandra, you want to make some comments on this first?
I think the question is for you.
Okay, so basically it's about migrant workers. This one is, I think, from an NGO in Koalisi Buruh Migran in Indonesia, saying what has happened to the workers who are detained in a detention center in Indonesia, prolonged detentions, conditions are bad, and they gave the report came out that there was the alleged torture in terms of food condition, treatment, dignity. So that is state official, and how do we respond to migrant workers being tortured? But there's a second question when torture is done not by government or state official, by non-state actor, like an employer, like domestic helper is a family that manages her or him, or a factory, the factory owner manages. So if the conditions are bad, living conditions are bad, salary is not bad, does that also come under the torture prevention framework? Thank you.
Thank you, Commissioner Gerald. The first question, if for Komnas HAM, our role and function is we are limited also with the jurisdiction of the state. Yeah, so we work on within the Indonesia border. But when it applies to other countries, for example, in Malaysia, we contact our colleague in Suhakam, like Commissioner Gerald, and also a colleague in other country if it apply in other country. For example, when there was a case with the fisherman worker in Chinese vessel, we contact the Korean Human Rights Commission. So that is how we work among the NHRI. But if it's in Indonesia, the Director General for Immigration guarantee that they will apply principle of human rights within their area of work. So if there is cases, please let us know about that. I think that's the first one, yeah. It's about the. I think that's it.
Okay, thank you, Commissioner Sandra. Hand it over to Shazira.
I'll just respond to the whole question of if it's a non-state actor, which I think is a very interesting and an important question as well. So if you look at the definition of Convention Against Torture, Article 1 of the Convention, it doesn't explicitly say that it encompasses private acts by person that have no connection with the state. But basically what it says there is more on the obligation to criminalize torture under the convention for the acts or commissioned of public officials. But however, looking at the ongoing discussion, this does not mean that the definition should be understood as only covering public officials. So as a matter of fact, if you look at some of the discussion that the committee comes up with, the committee has clarified that the Article 1 definition is broad and even has expressed concern where states defined public official as too narrowly. So I give you an example that Article 1 actually encompasses abuse committed by non-state or private actors if public officials knew or have reasonable grounds to believe that acts of torture are being committed by the non-state or private actors, and they fail to exercise due diligence to prevent, investigate, or prosecute the non-state or private actors. Then in that case, the officials should be considered as complicit or responsible for consenting to or acquiescing in such act. So this is how the definition of torture looks at non-state actors. So if you see at the moment in some of the deliberations made by the committee with some of the state parties, they're also looking into questions of trafficking in person, treatment of migrant workers, for instance. So just coming back to the question from Ria, in the CAT committee deliberation for Saudi Arabia in 2016, they actually commented and criticized on the issue of treatment of migrants in Saudi Arabia. So this is how the jurisprudence or the expansion of definition of torture are being deliberated at the moment. Thank you.
Thank you. Thank you for that, for helping us also expand that notion. I think we're coming to the end of our discussion time, but I want to mention, maybe this I take it as a proposal from Bambang also, who meant the question about the foreign workers. Since for NHRI's Ministry of Foreign Affairs and Ministry of Human Rights, since torture and ill treatment is an old and repeated problem for Indonesian migrant workers, I suppose all migrant workers in Malaysia, it's important to build a more comprehensive infrastructure for human rights protection and other necessary services in the borders of Batam and Nunukan. We take that as a proposal suggestion. Just to add on that, I think Commissioner Anam and myself and both Suhakam and Komnas, we've had, I think, 2 meetings already on how to work together on that report and to investigate further on the allegations of torture in the detention center. So that's going on. But yeah, honestly tell you, we are stuck because of so many red zones in Sabah and also now in Kuala Lumpur. So the travel has been restricted. So we're waiting to continue that work. But in the meanwhile, we are still getting information. So that's ongoing. Yeah? And I think maybe there's a question if there is any seminar materials that can be shared to us. I think maybe Shazira, you can put it on the chat box. I'm sure in your laptop there's a lot. So Shazira will share. We won't switch off the Zoom immediately after. We'll keep it on, and then Shazira, I'm just taking it for granted. Shazira, you have the documents on your laptop. Can you share some of the materials with them? Is it possible?
I'll try to
see
what I can put in there.
Okay,
yeah.
so the question is whether any text or seminar can be shared. Thank you for that. And also maybe that will answer Shahizad's question about difference between torture and ill treatment under the UN CAT. These 2 words are used differently, torture and ill treatment. Maybe that also can be shared in one of the documents. I think the committee would have answered that, yeah? Okay, maybe I'll just read out the final comment since we're coming to the end. Apakah ada solusi konkret dari lembaga-lembaga nasional ataupun internasional yang fokus terhadap HAM untuk mengajak negara membicarakan tentang peraturan maupun undang-undang mengenai penghapusan penyiksaan warga negara? We'll take this as the question to answer as we come to the close. Thank you, Didier. As we come to the close of this international seminar, I think we've heard a lot. So the first is to wish a big thank you to our 2 panelists, Commissioner Sandra and Ms. Shazira. So we can give a quiet clap at least to our friends, or you can also use the reaction to tell them. They have brought in a lot, but I also want to acknowledge our colleagues in all commissions, Myanmar Human Rights, Thailand, Indonesia, Malaysia, Philippines, Timor-Leste, for the work against torture. I think congratulations. I think Commissioner Sandra said correctly, our work is only as good as our sister commission across the border. So we always work collaboratively. In Malaysia, we have sent complaints to Myanmar, to Thailand, to Indonesia to help us take up some of the issues. So I think that's a good collaborative way. I think one big thing that strikes out is the work against torture is a work against the culture of violence, because it happens in the smallest private spaces, and that's why domestic violence happens a lot, because the private spaces is not resolved yet. No, people hide and get away. And then the broader society reflects that violence can get away with impunity. So I think we need to look at that whole chain of command, both in the government as well as society's chain of command culturally. How do we put a stop and break that culture of violence to say that violence is violence and it's a no-no, and get that from cultures, from our parents, family, religions. ASEAN is very strong in its religious beliefs, so we can even draw on that. Yeah? I think Thailand Commission reminded us that our work is to also look at the international obligations in domestication, so their work on drafting of laws. I think Shazira mentioned there's only 2 countries in ASEAN that have laws now on anti-torture. So congratulations to Thailand. They're closer on the draft act, and it's in line with the international obligations. I think the work of NHRIs is very clear. Monitoring, documenting torture. And I think Myanmar, Malaysia is with you. We don't sign UN CAT. While we say no to torture, but torture is happening. So at one level, dialogue. at one level investigating also torture that is happening. And I think that brings us maybe to the final points mentioned earlier, that it cannot be one part of society or one part of government that fights torture. I think the MOU, the Indonesian example, is a very good model that I think other NHRIs can reflect. If you can get 5 department agencies signing an MOU to fight torture, I think it's a loud message. And we have to work at many layers. So I heard the police, immigration, military being mentioned. We have to bring in other home ministries, the women ministry, the children's ministry, different levels to come in to have this MOU. And I also hear that NHRIs, we have to strengthen our resolve to investigate more, to bring that information out to public also, but also at the same time balance it with that dialogical manner of working with. So there's a moment where you call out, this is wrong, but there's also a moment where you go in to help work through dialogue, which is tough. And I think the hardest work is the society's education. I mean, Indonesia is 250 million population. Malaysia is maybe 35 million plus maybe a few more million foreigners here. Myanmar, I'm not sure, maybe almost 100 million people. So we've got a large population of 650 million in ASEAN. How do we do that work, to break that culture of violence? Because impunity continues if people think it's correct to continue. With that, I think we want to thank the inputs and experience and the struggles of all commissions, even the government who shared in the beginning, Indonesian government, of initiatives that have been done in the last many years. And you keep trying new initiatives. I think thanks to Shazira and APT, they bring good examples from different parts of the world, and we pick that up and we hope to learn. Malaysia's also learn. And also I think sometimes even in Malaysia, we are pushing, as mentioned, there's a ratification campaign for UN CAT. Still not there yet. I am really hoping, we are hoping in Suhakam one day we can announce it. But in the meanwhile, just on the issue of death row treatment, we were very happy that just last week, I think there was a UN General Assembly resolution on the moratorium of death penalty, that the Malaysian government co-sponsored the resolution. For us, that's hopeful. By co-sponsoring, it means that we are agreeing to a moratorium while we work out what to do with death penalty. I think that's one way of moving forward. When we don't know what's the real answer, okay, stop first, and and then find a solution. So I think in de facto, the last 10 over years, there has been a sort of a moratorium in Malaysia, not written in law, but I think this is a way for us to move forward. I think to all all human rights commissions, NHRIs here, our work is crucial in watching. By watching, we prevent. By watching, we know we can investigate. And by watching, we also know what to advise governments on how to improve laws and policies, using international standards, using best practices for our colleagues in other countries. And through that, we want to encourage all governments in ASEAN to have better standards. And I think I've not gone for a single meeting, a government meeting, where the government agrees that torture should be used. They debate how to do better interviews, how to be more effective, but no one ever says, please torture them. But we need to find the means to help empower our enforcement in order for them to move away from old style, where you use violence, you use coercion, where you hope people will give you the answers. And I think, thank you again to Shazira and Commissioner Sandra for putting it very clearly that the CNF work really is an important work on torture prevention. And let us work together for bringing this forward. And I think the role of NGOs, as you've seen the NGOs sharing the questions, they see the torture on the ground. The Bar Council, the legal partners, the lawyers who go into courts, listen to what happens, they should bring out, and they should be our key partners. So a big thank you to everyone, and congratulations to Komnas. And my apologies. I really don't know the 5 other organizing the MOU with the ombudsman. I cannot see the others, but the 5 organizing Indonesia. Congratulations! I think together with APT for having this and doing this. This gives us a good strength to continue our work on torture prevention. With that, big thanks to our 2 panel speakers and to the keynote speeches. I hand it over back to the MC from Komnas. Thank you very much.
Okay, thank you very much for Mr. Gerald, Mrs. Sandra, and Ms. Azira. Ladies and gentlemen, tomorrow we also have another event in 17th Annual Conference of the Southeast Asia National Human Rights Institution Forum, CNF 2020. To whom it may concern, you can join by Zoom the online dialogue Statelessness on Sabah tomorrow at 1 p.m. Jakarta time. Okay, thank you so much, ladies and gentlemen. Till we meet again in the next international seminar, may all of you have a nice day. Thank you very much and see you the next time.
Terima kasih semua. Thank you, Sajira.
Thank you, Ibu.
Thank you, Commissioner Gerald. Thank you, Pak Anton, Anjar,
Well
Ismi.
done. Well done.
Thank you, Jazira. Thank you, Sandra. Thank you, Gerald.
Thank you, Commissioner from
Thank you.
Myanmar. Thank you.
Terima kasih semua. Terima kasih
Thank you,
semua
Pak
panitia.
Anton.
Terima kasih. Thank you, Excellencies.
Thank you, Pak Tovan. Ponchai, Kapkun Ka. Thank you, Madam Profedora also, all of you. Thank you, translator.
Oh, the provider was in the attendee list.
Yeah. Thank you, Tan Sri. Udah ya?